Mr. Dasran Green, Director of Public Prosecutions of St. Lucia, other DPPs of the member states and territories, Mrs. Siobhan Spencer Joseph, Solicitor General of Grenada, and Solicitors General of the other member states and territories, Mr. Roddy Alcindor, Permanent Secretary of the Ministry of Justice in St. Lucia, and other permanent secretaries of justice ministries in the other member states and territories, Mrs. Michelle John Thibbles, Chief Registrar, and Miss Chambers, Deputy Chief Registrar of the Eastern Caribbean Supreme Court, Mr. Daniel Francis, Registrar of the High Court of Justice of St. Lucia, and registrars and deputy registrars of the high courts in each of the other member states and territories, Mr. Gregory Gerard, Court Administrator, and Mr. Francis Litang, Deputy Court Administrator of the court's headquarters and court administrators of each of the other member states and territories, Ms. Jean Dyer, President of the OECS Bar Association, Mr. Raman Rabino, President of the St. Lucia Bar Association, and Presidents of the Bar Associations of each of the other member states and territories, members of the Inner Bar, and we're pleased for the presence this morning in St. Lucia of Mr. Peter Foster and Mr. Dexter Theodore, King's Counsel of St. Lucia, all of the other King's Counsels of the other member states and territories, members of the Outer Bar, members of the clergy, members of the Diplomatic Corps, Assistant Commissioner of Police, Mr. Elvis Thomas, and other members of the Royal St. Lucia Police Force, Mr. Chris Felix, Acting Deputy Director of the Bordelais Correctional Facility, and heads of correctional facilities in the other member states and territories, staff of the court's headquarters and of the court offices in each of the member states and territories, distinguished guests, students. I'm very happy to see some of our students present, members of the media, and citizens and residents of the Eastern Caribbean. Good morning to everyone. It is my duty and my responsibility this morning, but also my honor and my pleasure to welcome all of you to the ceremonial opening of the 2005 law year, whether you are present in person or virtually. Each year, this special sitting provides us with an opportunity to collectively reflect on the challenges experienced and the successes attained by the Eastern Caribbean Supreme Court, the ECSE, and on the challenges and successes which lie ahead. I've had the pleasure for the last 15 years of being a participant at the formal opening of the law year. In September each year, from 2009 to 2020, and then in January each year, from 2020 to 2024. From 2009 to 2011, I participated as a High Court judge. From 2012 to 2024, as a Justice of Appeal. And I do so now in the capacity of Acting Chief Justice. During those 15 years, the Eastern Caribbean Supreme Court has overcome countless challenges and celebrated many milestones. We have heard and read criticisms of the court, its judges, and its judgments, occasionally with some justification, but usually baseless, and sometimes reckless. We have also witnessed firsthand the rapid evolution of our court with respect to both its human and physical resources. So we transitioned from a male dominated court, particularly at the higher levels, to a female dominated court, particularly at the highest level. From a technologically backward to a technologically driven court, and from a paper intensive to a near paperless court. But I want to focus at this time on the 2024 law year and the major undertakings of the court in the course of that year, and on what is to be expected in the 2025 law year. The three major undertakings of the court in 2024 were the electronic litigation portal, commenced before but completed in 2024, the introduction of AI technology, commenced in 2024 and to be continued in 2025 and beyond, and the public education program, commenced in 2024 and to be continued in 2025. Before the retrospective look, however, at the undertakings of 2024 and the prospective look at 2025 undertakings, I want to highlight for a while the volume of judicial work undertaken by this court. The statistics for 2024 are not yet available, so I will use the 2023 figures to tell the story of the work of the court in the course of 1 year. In 2023, a total of 7,742 cases were filed in the high courts in the 9 member states and territories of the Eastern Caribbean Supreme Court, whilst 8,083 cases were disposed of. This is a clearance rate of over 100%, meaning that the high courts as a collective are hearing more cases than are being filed, so that a dent is being made on the backlog of cases in the system. This is a promising indication that we have begun to reduce the case backlog. Indeed, this is the third consecutive year of an over 100% clearance rate, with an upward movement from 68.13% in 2021 to 104.4% in 2023. Clearance rates, though, are far from even, with a variation from 256.4% in Antigua and Barbuda to 34.62% in Dominica. The upward trend in the overall clearance rates may be credited to the impact of the implementation of the first 2 phases of the electronic litigation portal across all of the member states and territories. But robust measures are required to bring up to speed the states and territories with clearance rates of below 100%, particularly those with clearance rates as low as 34.62%. A total of 454 matters were filed in the Court of Appeal in 2023. The court, meaning the Court of Appeal, heard 324 matters in the full court sittings and 499 matters in chamber hearings. The court delivered 97 written judgments and 473 oral judgments. Like in the High Court, there is currently a more than 100% clearance rate of matters filed in the Court of Appeal. It is also evident that there is a very heavy caseload dealt with by the Court of Appeal, which is very significant given the relatively small size of the appellate bench. So both the High Court and the Court of Appeal of the Eastern Caribbean Supreme Court have been performing very well in terms of the clearance rates for matters filed in the courts and the rate of delivery of judgments in matters heard by the courts. And this level of performance, I might add, compares very favorably with courts within and without the Caribbean region. Indeed, it may well be said that we are streets ahead of our neighbors. But this is not to be taken to mean that there are no problems with delays in the delivery of judgments by some of our judges, or that there is not sometimes a lack of expedition by some judges in the conduct of proceedings. So there are delays sometimes on the front end or back end of court proceedings. But for us, it is a work in progress. And progress there has been in our work as a regional court. The major undertaking of the Eastern Caribbean Supreme Court in 2024 was the completion of all phases of the electronic litigation portal in all of the member states and territories of the court. The electronic litigation portal, or the e-litigation portal as it is usually referred to, was introduced in the Eastern Caribbean Supreme Court in 2018. The purpose of the e-litigation portal was to provide an electronic platform which would circumvent significant challenges associated with the traditional methods of filing and serving court documents in court proceedings in the Eastern Caribbean Supreme Court. In the 6 years since it was first introduced, the e-litigation portal has successfully transformed what was a time-consuming and resource-intensive process of filing and serving court documents into one which is efficient, cost-effective, transparent, and reliable. The e-litigation portal, it can be said, is the vehicle in which we drove from the practices of the past to the procedures of the present. The process of installation and operation of the e-litigation portal began in the British Virgin Islands in November 2018, from when all High Court civil cases in the BVI had to be filed on the e-litigation portal. And the process was completed in Montserrat in December 2024, from when all criminal cases in Montserrat had to be filed on the e-litigation portal. All the other case types in Montserrat and all case types in all of the other member states and territories had by then been onboarded on the e-litigation portal. Until 2018, when the filing of court documents on the e-litigation portal first began, the Eastern Caribbean Supreme Court was a virtual paper factory, generating large quantities of paper to institute and conduct proceedings in its court, whether in the High Court or the Court of Appeal. Every document to be filed in the High Court had to be filed at least in triplicate if there were only two parties to the proceedings. If there were more than two parties, additional copies had to be filed for each other party to the proceedings. In the case of the Court of Appeal, at least 6 copies of every document had to be filed at the court office, with additional copies to be filed if there were more than two parties to the proceedings. Given that there were 7,742 cases filed in the High Court in 2023 and 454 filed in the Court of Appeal in that same year, with an average of no less than 100 pages of statements of case, witness statements, submissions, and exhibits for each High Court case, and at least the same number of pages of notices and counter notices, transcripts of proceedings in the court below, and submissions for each Court of Appeal case. If you do the maths, recalling that at least 3 copies of every document had to be filed in the High Court and 6 copies in the Court of Appeal, this yielded about 2,600,000 sheets of paper generated every year for the filing of documents in all of the cases filed in the Eastern Caribbean Supreme Court. With the onboarding now complete as of December 2024 of all matters filed in the High Court and the Court of Appeal, and the requirement now to download a copy of only the originating documents in a case for service on the other side, that is, the claim form and statement of claim in a High Court case and the notice of appeal in a Court of Appeal case, this generates only about 116,000 sheets of paper for High Court cases and about 4,500 for the Court of Appeal, yielding a total of about 120,500 sheets of paper every year for the institution and conduct of proceedings in the High Court and Court of Appeal. This results in a net saving of about 2.5 million sheets of paper every year. Even though some of the estimates may be overstated or understated, the results are nonetheless astonishing. And it is not the trees alone which benefit from this enormous saving of paper. The staff of the court offices who were required to sort and manage these volumes of paper must be much happier campers now with 2.5 million sheets of paper less to sort and manage. The lawyers, the judges, and all others who had to work with these volumes of paper have all been rescued from the prison of printed paper to which they were confined for several years. The occasional misfiling and misplacement of documents through simple human error, as would occur from time to time, the loss and destruction of documents through natural disasters, as occurred in Dominica in 2017, and the illness and discomforts resulting from paper overload at the court offices, attracting dust and mold, which have proven to be hazardous to court personnel and disruptive to court offices, because court offices have had to be vacated and evacuated sometimes because of problems with and/or complaints about dust and mold. All of this has now been averted by the near paperless operation of our courts in the Eastern Caribbean as of the end of the last court year on 22nd December 2024. The e-litigation portal has also eliminated the requirement to serve documents on parties all over the country and even by alternative service outside of the country. All documents, apart from originating process documents, are deemed to be served once they are filed on the portal and the other party or parties have an authorization code. The e-litigation portal has also eliminated the requirement to physically file documents by the court office deadlines from 2 p.m. in St. Lucia and Antigua to 4:30 p.m. in Dominica. With the e-litigation portal now in full operation, court documents in any case can be filed anytime, anywhere, and on any device. So you can file a witness statement in a High Court case in Anguilla, or submissions in a Court of Appeal case in Grenada at midday or midnight, at a bar in Barbados or in an Uber in Aruba, on your cell phone or your laptop. Yes, anytime, anywhere, on any device. The completion of the implementation of the e-litigation portal did not end our efforts to modernize the operations of the Eastern Caribbean Supreme Court. Even as we sought to use the e-litigation portal to drive us along the road to judicial modernity, we continued our other efforts at modernizing the ECSC and our court system as a whole. So that whilst we were progressing with the full implementation of the e-litigation portal, we commenced 2 other digitization projects which have taken the Eastern Caribbean Supreme Court into the realm of AI technology. We commenced the use of an AI technology in the ECSC, commenced the use of AI technology in the ECSE by the use of a speech-to-text transcription system in courtrooms where civil cases are being heard. The technology is expected to deliver court transcripts in nearly real time with 95% accuracy. This, of course, is, to say the least, a very welcome improvement in the conduct of the work of the Eastern Caribbean Supreme Court, which will significantly enhance the accuracy of court records and, more especially, will significantly reduce the time taken to produce transcripts of court proceedings. Delays in the production of transcripts had reached near crisis proportions in some of our member states and territories and were causing a backlog in the hearing of appeals in the affected countries. With the introduction of this AI technology, these embarrassing delays of weeks, months, and sometimes even years for the production of transcripts should come to an end, and transcripts from the territories where the technology has been installed should be produced in days and not weeks, months, or years from the hearing of the case. This new technology, the FTR Justice Cloud Platform, as it is called, was installed in one courtroom in St. Kitts Nevis in February 2024, in Grenada in April 2024, in St. Vincent and the Grenadines in June 2024, and in Dominica in September 2024. We expect to install the FTR Justice Cloud platform in the other 5 states and territories in the course of the new law year, with the installation of the technology in at least one courtroom in St. Lucia, Antigua and Barbuda, Anguilla, Montserrat, and the British Virgin Islands expected by July 2025. Another new but related court technology, which was introduced in the Eastern Caribbean Supreme Court in 2014, is the Microsoft Azure AI technology, which was deployed to address the backlog of recordings previously done on the Liberty audio recording platform throughout the member states and territories. This new technology is expected to produce transcripts with up to 80% accuracy from the recordings of cases previously heard. The technology was implemented since June 2024, but its use is constrained by the fact that the High Court registries need to request the court's headquarters to prepare the transcripts using Microsoft Azure AI. We are, however, working on making the adjustments that would allow the technology to be used independently by the High Court registries in all of the member states and territories, so that the registry in each state or territory will be able to prepare its transcript on its own for cases heard there. In the course of the new court year, the Eastern Caribbean Supreme Court will continue to leverage new technologies to improve its court processes and to look for other areas where AI technology can be employed to improve the efficiency and effectiveness of the justice system in the Eastern Caribbean. Another major activity of the court, which commenced in the 2024 law year and will be continued in the 2025 law year, is the public education program. I have long held the view that there is insufficient knowledge and understanding about the court system in the Eastern Caribbean. And by the court system, I mean all of the courts which operate within our common juridical space. The Eastern Caribbean Supreme Court is the centerpiece of the court system in the Eastern Caribbean, but it is not the only institution within our court system. The ECSE comprises the High Court in each of the 9 member states and territories served by the court, and the Court of Appeal, which is a single court hearing appeals from the high courts of all of the member states and territories, and also from the Magistrates' Court. But apart from the High Courts and Court of Appeal, which make up the Eastern Caribbean Supreme Court, There are courts at the base level and at the apex level of our court system. At the base level of our court system is the magistrates' courts, which operate in all of the member states and territories. The number of magistrates' courts in the member states and territories range from 1 in Montserrat to 14 in St. Vincent and the Grenadines. At the apex of our court system is the Judicial Committee of Her Majesty's Privy Council, usually referred to as the Privy Council, and the Caribbean Court of Justice, usually referred to as the CCJ. 2 of the 9 member states of the Eastern Caribbean Supreme Court, namely Dominica and St. Lucia, have the CCJ as their final court of appeal, while the other 7 member states and territories continues to have the Privy Council as their final court of appeal. But is our court system and its various components understood by the public? The answer is a resounding no. And this lack of understanding is not restricted to the hypothetical man on the street. It exists too amongst men and women in every strata of the countries in this common juridical space that we share. The same is true of the awareness of our citizenry about the judicial officers who man the court system. Who or what is a magistrate, and how is this judicial officer referred to? Who is a judge, a High Court judge, Court of Appeal judge, CCJ judge, and the law lords who preside over cases in the Privy Council? Who are these people? What do they do? What are they called? None of these are questions which can be answered by most of our citizenry in the Eastern Caribbean. There are several other aspects of our court system and our judicial system which are not understood by the people served by them. And I should add in passing that this lack of understanding is made worse by the wholesale consumption of American television, with its Judge Judys and other such fictional characters, and its real-life US $150 million awards for criticizing an election clerk, which both reflect a court system very different from ours, but mistaken by many to be the same or similar. To combat this lack of understanding and awareness, I have initiated a public education program designed to educate the people of our 6 states and territories about our judiciary and our court system as a whole. There are various components of the public education program, 3 of which have already commenced. The first component of the public education program, which we've started, is the visits to the community colleges in the member states and territories. Thus far, I have visited and addressed the students of the Dominica State College, the Antigua and Barbuda Community College, the Fitzroy Bryan Community College in St. Kitts, the Nevis Sixth Form College, the Anguilla Community College, the Montserrat Community College, and the Sir Arthur Lewis Community College in St. Lucia. I have not yet addressed the community colleges in Grenada, St. Vincent and the Grenadines, and the British Virgin Islands, but this should be done in the first term of the new law year. The school visits and interactive exchanges with the students were for me very valuable to both the court and the students in terms of breaking down barriers between the community and the court and demystifying law and its practices and procedures. The second component of the public education program, which was started in 2024, is the lecture series, which aims to address issues of interest and concern to the bench, the bar, and the public. The first lecture in the series was delivered by Senator Garth Wilkin, the Attorney General of St. Kitts and Nevis, who spoke on the topic, and I quote, "Justice Without Borders, the Legal Practitioner's Perspective and the ECS's reality, end of quote. Senator Wilkins' lecture was delivered at the Marriott Hotel in St. Kitts and was very well attended and very well received. It was also live streamed to a virtual audience. The next lecture in the series will be delivered during the course of the first law term between tomorrow, 11th January, and Wednesday, 16th April 2025. The date, venue, and speaker will be determined and circulated by the Public Education Committee, which is responsible for coordinating the public education program. The third component of the public education program, which also started in 2024, is the Conversations with the Chief Justice. The first of the conversations took the form of an interview with Mrs. Natalie Jolie Fannis, a communications specialist from St. Lucia. The interview is expected to commence broadcasting in the course of this month. The first interview was very wide-ranging in its content, but those which follow may be narrower in their focus or range. There are other components of the public education program, including a regional debating competition among community college students, an animation and art competition among primary and secondary school students, an exhibition, panel discussions, seminars, workshops, conferences, and other such forums for discussion of issues of interest to the public and relevance to the Eastern Caribbean Supreme Court and the court system in its member states and territories. In terms of other undertakings of the Eastern Caribbean Supreme Court commenced in the last court year and continuing to the next, the court has secured funding for and undertaking projects aimed at improving justice administration across the Eastern Caribbean. One such project, which has recently commenced, is the Opportunities to Advance and Support Youth for Success, OASIS, which project was developed through the ECSE's partnership with the OECS Commission and the United States Agency for International Development, USAID. The project is aimed at transforming the youth justice system by providing pathways for diversion, rehabilitation, and reintegration of children and youth in conflict with the law. The project also emphasizes strengthening data systems to guide decision-making and enhance case management for these youth. The Eastern Caribbean Supreme Court is eager to fulfill the mandate of this project within its 2-year duration. To do so, the court needs and intends to focus on the introduction of criminal mediation and the continued support of the expansion of the family division across our 6 member states. We are of the view that the extension of the practice of mediation to our criminal courts is certain to alleviate the persistent case backlog, as it has done for civil matters. By implementing criminal mediation, the Eastern Caribbean Supreme Court aspires to do the following. 1. Reduce court dockets by addressing minor offenses promptly, thereby alleviating the burden on court schedules and allowing for a greater focus on more serious cases. 2. Engage alternative sentencing guidelines by supporting initiatives aimed at reducing prison overcrowding, particularly in relation to youth offenders who should not be placed alongside adult offenders. And 3. Utilize criminal mediation as a diversionary measure by offering child and youth offenders reformative strategies without the lasting repercussions of a criminal record. We are optimistic that this project will realize tangible, positive, and enduring impacts on the criminal justice system. We also look forward to strengthening the Family Division pilot project for Antigua and Barbuda and realizing opportunities for expansion of the Family Division in Dominica and Grenada. Two other projects which commenced in the last year are the Partnership of the Caribbean and European Union on Justice Project, what is called the PACE Justice Project, implemented by the United Nations Development Programme and funded by the European Union, and also the Justice Education Society, the JES project, funded by the Government of Canada. Both projects will focus on criminal backlog reduction in select member states. Further details on these very key projects can be obtained from the ECSE's annual report for 2023 to 2024, available on the court's website. There are also several other small projects which the court has undertaken and or completed within the last year, which time will not permit elaboration on, but information on which can be obtained from the annual report available on the website. Among the other undertakings of the Eastern Caribbean Supreme Court in the course of 2024 law year were education and training activities designed to improve the knowledge base of both judicial and non-judicial staff of the court. The Judicial Education Institute, JEI, which is the educational arm of the Eastern Caribbean Supreme Court, organized and hosted various activities during the course of the year with the aim of broadening and deepening the knowledge base of judicial officers and court staff within our subregion. Some of the activities were for the benefit of judicial officers, while others were mainly for the staff of court offices in the member states and territories. By all indications, all of the activities organized and hosted by the JEI were successful and met their desired objectives. The JEI's signature activity, though, is the annual Judicial Conference, which was held in St. Lucia in August last year. Judges and masters and other officers of the court convened at the Coco Palm Hotel at Rodney Bay in Gros Islet, St. Lucia, to engage with an impressive panel of facilitators who made presentations on topics related to the subject matter of constitutional and administrative law. The facilitators included judges from our court, from the Supreme Court of Jamaica, and from the Caribbean Court of Justice. Each presentation offered an in-depth analysis on critical areas of constitutional and administrative law and generated lively and stimulating discussions on the issues addressed by the facilitators. The JEI's programs are expected to be increased this year, with its signature event scheduled to be held in August this year on a date, time, place, and a topic yet to be determined. The JEI has also partnered with the OECS Bar Association by providing facilitators to present at the 18th Regional Conference held in St. Lucia in October 2024. This partnership with the OECS Bar Association is symbolic of the ECSE's commitment to fostering a cooperative relationship between the bar and the bench, and I look forward to the continued advancement and enhancement of this relationship. I am skipping over some parts. There is much that I would have liked to address this morning, but I'm very conscious of the demands of your time and of the law of diminishing returns. So I will try to end now. But it would be remiss of me if I did not take this opportunity as what is simultaneously the closing of the 2024 law year and the opening of the 2025 law year to place on record my gratitude to those who, by their work, have contributed to the progress and development of the Eastern Caribbean Supreme Court in particular, and our court system in general. I extend heartfelt thanks to the appellate and high court judges and masters of the Supreme Court who have served this court well in their years on the bench, especially during the course of the last year. I extend heartfelt thanks as well to the Chief and Deputy Chief Registrar and the High Court registrars and deputy registrars throughout the 9 member states and territories for their hard work and dedication in 2024. The Court Administrator of the Eastern Caribbean Supreme Court and the staff of the court offices, both at the court's headquarters in St. Lucia and in each of the 9 member states and territories, also deserve our appreciation and gratitude. Not to be forgotten, and I would not be permitted to forget, are the orderlies assigned to the High Court and to the judges and masters of the Eastern Caribbean Supreme Court. You too have played your part in contributing to the work of the court. To the magistrates and the staff of the magistrates' court offices throughout the member states and territories, although you are not part of the Supreme Court, your good work is essential to the smooth functioning of the Eastern Caribbean Supreme Court and the court system of which it is a part. I also extend my gratitude to the OECS Bar Association and the constituent bar associations of the Eastern Caribbean for their cooperation and collaboration with the judiciary in the course of last year. I would like to express thanks as well to our external partners and the donor agencies which have contributed significantly to the work of the Eastern Caribbean Supreme Court, especially by the funding which they provided to the court. These partners and donors include the Government of Canada, the United States Embassy, the British High Commission, the European Union, UNICEF, UN Women, UNDP, USAID, the University of the West Indies, and the OECS Commission. We are grateful for your partnership and your investment in the work of the court, and we look forward to continuing this meaningful collaboration in the pursuit of justice. Special mention must be made of our former Chief Justice, the Right Honorable Dame Janice Pereira, who gave 21 years of her life to the judiciary in the Eastern Caribbean, 12 of which as Chief Justice of the Eastern Caribbean Supreme Court, making her not only the first and only woman to hold the office of Chief Justice, but also the longest-serving Chief Justice. Much can be said about the contribution of Dame Janice to the court, but there is very little which would not already have been said in the 8 months since she demitted office. So it remains only for me to say, thank you, Dame Janice, for your seminal contribution to our court. As I close this address, I am hopeful that our court's efforts to bridge the gap with our community through the public education program will not only demystify the law and the judiciary for the citizenry which we serve, but will also reinforce the idea that justice is a collaborative endeavor that serves and reflects our collective values. Through these efforts, it is our hope that the court will be seen as more than just a place of adjudication, but also a cornerstone of public trust and societal progress. It is my hope that we will approach the new law year reaffirming our shared commitment to the principles of justice, fairness, and integrity that underpin the foundation of the work of the Eastern Caribbean Supreme Court. Together, we have the opportunity to make a meaningful impact in our communities and to uphold the ideals that are the bedrock of our legal system. Law, they say, is a jealous mistress, but it is Lady Justice who is the wife, and she shows no envy, only fairness and equity. Let us therefore, as judicial officers charged with the dispensation of justice, do so with the fairness and equity by ensuring justice for all. Thank you all, and I wish you a pleasant and productive year in 2025.
His Lordship, the Honorable Mr. Mario Michel, Chief Justice, Acting, Their Excellencies, Heads of State of the OECS, Honorable Heads of Government of the OECS, Honorable Justices of Appeal, Judges and Masters of the Eastern Caribbean Supreme Court. With your gracious permission, I shall adopt the protocol list as thoughtfully established by His Lordship, the Honorable Mr. Mario Michel, Chief Justice. Good morning. Welcome to this special sitting marking the opening of the law year 2025. I am Justice Taylor Alexander, a resident High Court judge in St. Lucia assigned to the Criminal Division, and I am your Master of Ceremonies for this sitting to mark the opening of the law year 2025. This year's opening adopts a blended approach with the court and some of our speakers physically present here in St. Lucia and others appearing virtually. We continue to embrace technology to bring us together despite the geographical divide of our 9 member states and territories. Having just heard the Honorable Acting Chief Justice's feature address, I do not doubt that you have all been inspired and look forward to the continued improvement of our justice system as the court navigates the changing tides while bridging the gap through community engagement. At this juncture in these proceedings, we will now hear from the members of the public and private bar of each of the member states and territories of the OECS. Our first speaker from the bar is none other than the Honorable Mr. Leslie Vincent Mondesi, Attorney General of St. Lucia. The Honorable Attorney General was born in Castries. He attended the R.C. Boy Primary School and later succeeded to St. Mary's College. During his earlier years, he served as prosecutor at the Office of the Director of Public Prosecutions and then went on to private practice. Mr. Mondesi has over 25 years of experience as an attorney. He is a conscientious and hardworking individual. In July 2021, Mr. Mondesi was appointed the Attorney General of St. Lucia. To present the address on behalf of the Attorney General of the OECS and St. Lucia, I present to you the Honorable Mr. Leslie Vincent Mondesi, Attorney General of St. Lucia.
Your Excellencies, Heads of State of the OECS, this morning I wish to recognize our own, His Excellency, Mr. Cyril Errol Charles, Governor General of St. Lucia, and Mrs. Charles. Your Lordship, the Honorable Mr. Mario Michel, Acting Chief Justice of the Eastern Caribbean Supreme Court, Honorable Heads of Government of the OECS, Honorable Heads of Regional Judiciaries, Honorable Justices of Appeal of the Eastern Caribbean Supreme Court, Honorable High Court Judges and Masters of the Eastern Caribbean Supreme Court, Honorable Ministers of Legal Affairs in each of the OECS member states and territories, my colleague Honorable Attorneys General in each of the OECS member states and territories, members of the Diplomatic Corps, and today I wish to recognize, I think I saw her this morning, Ambassador Escalona of Venezuela, who should be in the audience this morning, Honorable Chief and Senior Magistrates and Magistrates in each of the OECS member states and territories, learned members of the Inner and Outer Bar in each of the OECS member states and territories. I wish to recognize learned King's Counsel, Mr. Peter Foster and Mr. Dexter Theodore, who are here with us this morning, staff of the court's headquarters and the High Court offices in each of the OECS member states and territories, members of the media, students present, ladies and gentlemen, good morning. It is an honor and distinct privilege to address you today at the opening of Law Year 2025 on behalf of my colleague Attorneys General of the 9 member states and territories that constitute the Eastern Caribbean Supreme Court. This year's theme, Accessibility and Awareness, The Eastern Caribbean Supreme Court, bridging the gap through community engagement, is indeed a thought-provoking and engaging subject. It provides an opportunity to reflect on the progress made in improving access to justice and increasing legal awareness within our region. It speaks to the core of the judicial mission in the Eastern Caribbean, a mission that seeks to make justice not a remote ideal, but an everyday reality for all. It invites us to reaffirm our commitment to the enduring values of justice, equality, and accessibility. It is well established that the core of our justice system is underpinned by the principle that all citizens have the right to equal protection under the law. This means that the court must always provide a fair and impartial hearing and also ensure that these services are readily available to all, regardless of their educational background, their financial situation, or their knowledge of the law. Moreover, if we believe that justice is a fundamental pillar of any democratic society, it is imperative that citizens of member states feel that justice is accessible in all areas by virtue of the ability to approach the court, being able to pay the fees associated with the court processes, and justice is seen to be done by having access to timely and well-reasoned decisions. The Eastern Caribbean Supreme Court has attempted to dismantle some of the geographic and financial challenges that have historically limited access to justice in our region. The introduction of the virtual courts and remote hearings are tangible steps in that regard. By embracing technology, those jurisdictions have enabled individuals from remote locations to participate in hearings without the need to travel long distances. It means, therefore, that individuals and legal practitioners who live and work across the region and beyond can now participate in the judicial process at significantly reduced costs, without the logistical barriers which previously hindered them. In St. Lucia, there has been an increase in public law cases in the form of constitutional complaints and judicial review of administrative actions, which suggests that persons are becoming more aware of their public law rights and have ready access to the courts in their desire to enforce those public law rights. The Eastern Caribbean Supreme Court has further demonstrated its willingness to embrace technology, to improve accessibility and efficiency in the legal system with the launch of the Family Court module of the e-litigation portal in St. Lucia, Antigua and Barbuda, and the BVI in 2022, and the e-litigation portal in the Criminal Division of the High Court and Magistrates Court in St. Lucia in October 2024. This allows for the filing of proceedings and documents online, anywhere, and at any time with relative ease. As the Chief Justice said, from a bar in Aruba, from anywhere in the world, you can file your documents. And in that regard, I wish to recognize the contribution of our former Chief Justice, the Right Honorable Dame Janice Pereira, in the e-litigation advance. The introduction of online resources like the Eastern Caribbean website, which hosts a range of self-help tools, guides, and information on how to navigate the court system, is a positive step towards ensuring that people not only have access to the legal system, but also understand how to use it effectively. Undoubtedly, the discussion surrounding this year's theme will bring focus and life to these innovative measures and promote them to the people of the OECS. I am pleased to note that the Eastern Caribbean Supreme Court has embarked on a revision of the criminal procedure rules, which seeks to revise and update criminal procedure in the Eastern Caribbean. In an effort at making this an involved project, the court has asked that stakeholders and members of the public submit their comments, thus allowing the community to participate in criminal justice reform. In his budget address of 2024-2025, Prime Minister the Honorable Philip J. Pierre announced that the Alliance for Community Transformation, ACT, was launched in January 2024. The ACT initiative provides a practical framework for the holistic approach to crime risk reduction and prevention. This agency brings together support services, counseling, educational interventions, community outreach, crime prevention programs, law enforcement, and economic opportunities that are easily accessible to the youth at the community level. It is worthy that a similar program was recently signed by the Eastern Caribbean Supreme Court. On Friday, November 1st, 2024, the Director General of the OECS, Dr. Didacus Jules, and the Honorable Chief Justice signed a sub-grant agreement under the United States Agency for International Development, USAID, funded OASIS project. And OASIS means the OECS Opportunities to Advance and Support Youth for Success. The court will be able to use counseling, mediation, and alternative sentencing mechanism to divert children and youth in conflict with the law away from incarceration and towards rehabilitation. It is arguable that one of the most practical and effective ways to bridge the gap between the courts and the public is through community engagement. It is also commendable that the Eastern Caribbean Supreme Court has shown its ongoing commitment to community engagement over many years and must continue to build on the successes of its Justice in School tours and public education lecture series. The Eastern Caribbean Supreme Court must strengthen its community outreach program, which will continue to play a critical role in educating the public into the foreseeable future. Another notable example of this commitment is the mounting of this annual Eastern Caribbean Supreme Court Law Week initiative. During this week, legal professionals from across the region will engage in public education campaigns and legal literacy workshops. These activities have been successful in educating students who are present, young professionals, and citizens on their legal rights and the importance of the rule of law. Every effort must be made to ensure that the educational activities of Law Week reach communities across the OECS, to ensure that legal knowledge is not confined to urban centers, but is also reaching rural communities. I firmly believe that more public forums, legal clinics, and partnerships with the community are needed to raise the awareness about legal rights and responsibilities of our people. These public interactions with the judiciary will provide much needed legal information and also promote a deeper understanding of the relevance of the law to the citizens of the OECS. As the judiciary listens to the needs and concerns of the people, and the people themselves gain a better understanding of the legal process, it will help to foster trust between the courts and the community. As a suggestion in the St. Lucian context, what about an Eastern Caribbean Supreme Court Town Hall Thursday in the communities around the island of St. Lucia to meet the people of St. Lucia and engage them? Though English is the official language of the court in St. Lucia, we would like to see our court speak Creole to our people. You want St. Lucians to own the court? Then speak to us St. Lucians in our native language, Creole. I am aware that our present Chief Justice is quite versed in our Creole language and is an effective communicator in Creole, far better than I could ever be. And as I look up at the bench here today, I see a number of St. Lucians sitting on the bench. So let me say this. Vini di nou sakin lo dias premier, seti pays Caraïbes la, san nou ka kriye OECS Supreme Court. I think only 6 persons on the bench may have understood what I just said there. I know Mr. Foster didn't understand what I said. But I will translate it and say, come tell us, the people of St. Lucia, about this court called the Eastern Caribbean Supreme Court. Your Lordships, there is much more I can say on behalf of my colleague attorneys general, because as you know, some of us are politicians and others quasi-politicians, and you know we like to talk a lot sometimes. And I may have already breached the time allocated to me, which was only 7 minutes. So in conclusion, I had an outreach, yes, I've gone over the 7 minutes. So in conclusion, as we commence the law year 2025, let us reaffirm our commitment to the principles of accessibility, equality, and awareness, and to creating a legal system that serves everyone, ensuring that all citizens of the OECS feel empowered to seek justice and participate in our legal system. I want at this time to reaffirm the commitment of the Attorneys General of the 9 territories that subscribe to the Eastern Caribbean Supreme Court. I thank you, my lady. Thank you very much.
Thank you, Honorable Attorney General. Our next speaker, Her Honor, Mrs. Candia Carrette George, holds an LLB from the University of Wolverhampton, professional legal skills from the Inns of Court School of Law, and an LLM from the University of London. From 2001, Her Honor worked as State Attorney at the Attorney General's Chambers, the Legal Aid Clinic, and the Office of the Director of Public Prosecutions. Her Honor was appointed magistrate in May 2008 and became Chief Magistrate in November 2013. To present the address on behalf of the magistracy of the OECS and as representative for the Commonwealth of Dominica, I give you Her Honor, Mrs. Candia Corrette George, Chief Magistrate of the Commonwealth of Dominica.
Allow me to adopt the protocol that has already been established. Good morning. It is my distinct pleasure and honor to address you today on behalf of the Commonwealth of Dominica and the OECS Magistracy as we gather to mark the opening of the 2025 Law Year. I extend a warm welcome from the Nature Isle of the Caribbean, Dominica. This year's theme, Accessibility and Awareness, the ECSC Bridging the Gap Through Community Engagement, speaks to the very core of the direction our courts are moving in. It resonates with our shared commitment to improving the accessibility of justice and enhancing the public's understanding of the judicial process. In Dominica, 2024 was a year of significant progress. One of the major highlights was the appointment of a third judge, His Lordship Justice Davidson Baptiste, from September 23rd to December 22nd, to address the backlog of land-related matters. His Lordship sat 13 times, conducted status hearings for 89 matters, and reviewed 118 applications for first titles and cases stated. This intervention has positively impacted access to justice for many awaiting resolutions in land disputes. We hope for an extension of his appointment into 2025. The Dominica Bar Association, DBA, embodied this year's theme with commendable initiatives: a bi-weekly radio program, Legally Speaking, educating the public on legal matters, a public panel discussion on the admissibility of digital evidence during the Law Week 2024, a high school public speaking competition centered on digital themes, pro bono legal services during Law Week, and of course, Voices of the Bar, the DBA's choir, spreading Christmas cheer with visits to senior homes and shelters, along with care item donations to a value of $4,000. In infrastructure improvements, the Magistrates Court's main building received a facelift, including new paint, proper signage, and the installation of a canopy and washroom facilities for its waiting area. These enhancements aim to provide a more comfortable and dignified experience for court users. I wish to express my sincere thanks to the Honorable Minister of National Security and Legal Affairs for being the driving force behind these initiatives. In human resource development, 6 staff members of the Magistrates Court were permanently appointed to positions in which they had been acting, fostering greater professionalism. Additionally, a new magistrate was engaged and posted to the Northern District, which had been without a magistrate from April of the previous year, alleviating delays in access to justice for residents in that district. Training programs were conducted by the ECSC in case flow management and customer service, thus improving staff competence. Through a partnership with the UNDP, the PACE project provided training for the court staff, and in a remarkable show of support during the last week of 2024, donated laptops and printers to assist with the reduction in the criminal backlog. It is noteworthy that at the Dominica Magistrates Courts in 2024, a total of 2,190 cases were filed and 2,405 cases were disposed of, thus reducing the backlog by 215 cases. My heartfelt thanks go out to the staff of the Dominica Magistrates Court for their hard work and dedication, which assists in the smooth functioning of the court. In Antigua and Barbuda, the Magistrates Court reached a significant milestone with its relocation to newly renovated headquarters on High Street on September 16, 2024. This move, following over 4 years of repairs and reconstruction, has improved access to justice for the people of Antigua. The upgraded facilities have enhanced the work environment for staff and ensured better service for court users. We extend our congratulations to the judiciary and staff in Antigua and Barbuda for this accomplishment. In St. Vincent and the Grenadines, the magistracy faced numerous challenges during 2024. including the devastating impact of Hurricane Beryl, a Category 4 storm. Of the 3 magisterial districts, the third was severely affected, with 2 courts, the Union Island Magistrates Court and the Canoan Magistrates Court, remaining non-operational. However, the magistracy has embraced technology to ensure continuity, utilizing video links to hear cases from affected areas. Additionally, the courts in the 3rd magisterial district in the St. Vincent and the Grenadines transitioned to typewritten notes, reducing the production time for notes of evidence and reasons for decisions. The creation of a 2nd senior magistrate post is a significant step forward, and efforts to reduce the backlog of coroner's inquests in St. Vincent have been successful, with only 2 pending inquest matters remaining. These achievements underscore the resilience and dedication of the judicial officers and staff in the St. Vincent and the Grenadines. In Grenada, Hurricane Beryl also caused significant damage to the court facilities on the sister island of Carriacou. Repairs to the roof and electrical systems have been completed, and efforts are underway to rebuild and source furnishings for the court. Meanwhile, staff training initiatives conducted in October 2024 have improved professionalism and work ethic among court personnel. The Grenada Magistracy looks forward to further collaborative efforts to enhance service delivery. In St. Lucia, technological advancements have taken center stage. Virtual hearings have been instrumental in ensuring the smooth functioning of most courts, facilitating bail hearings, case management, and the review of prisoners on remand, the need for transportation. The initiatives have enhanced efficiency and reduced delays and improved the trial process, where, for example, witnesses are out of state or physically unable to attend the trial. Further, funds have been allocated for the establishment of a fully functioning coroner's court and traffic unit in St. Lucia. These initiatives aim to address the backlog of traffic matters and improve the overall administration of justice. Across other OACS territories, the judiciary continues to prioritize modernization and accessibility. Notable achievements include adoption of digital systems. The ECS's commitment to modernization is evident in the ongoing digital transformation across member states. With the launching of the criminal module of the ECSC's e-litigation portal across all our member states and territories in 2024, we have now achieved full implementation of the portal. This has revolutionized court services, allowing for online filing and case management. This shift to a paperless judiciary not only enhances efficiency, but also safeguards records from disasters like Hurricane Maria. As we embark on the 2025 law year, I am pleased to report that our courts are making significant strides towards greater efficiency, accessibility, and public trust. While challenges remain, our collective commitment from the judiciary to Bar Association and support staff ensures that justice remains a living, breathing part of our communities. Together, let us continue to bridge the gap, making justice accessible to all. I wish everyone a fruitful and productive law year ahead. Thank you. If it pleases your lordship.
Mrs. George, Chief Magistrate of Dominica, I thank you. Our next speaker hails from the Twin Island state of Antigua and Barbuda. Mrs. Shannon Jones Gittens began her legal career as Crown Counsel 2 in the Office of the Director of Public Prosecutions. Having worked diligently for over a decade, she was elevated to the post of Crown Counsel 1 and then Senior Crown Counsel. In November 2022, she was appointed to act as the Director of Public Prosecutions and continues to serve in that role, remaining steadfast in her dedication to public service. To address us on behalf of the Director of Public Prosecutions of the OECS, and as the representative for the Antigua and Barbuda Office of Director of Public Prosecutions, Mrs. Shannon Jones Gittens.
Please allow me to adopt the protocols so it is established. and to extend warm greetings to all of you from the beautiful Twin Island state of Antigua and Barbuda, and on behalf of the Directors of Public Prosecutions of the member states and territories. I'm quite honored and humbled by this invitation to present this address. In preparation for today, I was compelled to consider the theme for the law year: accessibility and awareness, the Eastern Caribbean Supreme Court, bridging the gap through community engagement. It immediately called to mind the public education programs, which has been conducted by the court, and the tours of the several colleges. I was quite impressed by this initiative, the court engaging with our young people, and not just the court, but the Chief Justice himself. This must have been a very impactful and unforgettable experience for these youths. The court, in its usual manner, has set an example for us to follow and issued a timely reminder about an important feature of our collective work. In the criminal courts, we have seen similar initiatives before in the member states, such as right here in Antigua and Barbuda, when the Sexual Offences Model Court was launched. A video was publicized that walked persons through the entire process, from report to verdict. So this benefited accused, complainants, witnesses, and even jurors. It helped them to learn about the process. Also, Justice Morley, when he was here, did several school visits and has seemingly continued his awareness efforts in St. Kitts and Nevis. As recently, he and the DPP there were scheduled to discuss the sentencing guidelines on a radio broadcast. In St. Vincent and the Grenadines, there are anti-crime, student, and community engagement programs which sees the office of the DPP going into the schools and the wider community to discourage criminal activities, but also to spread awareness of the functions of their office. The main purpose of programs like these is to take some of the mystery out of the court and its processes, so that because many persons are usually intimidated by it. Now, we cannot underestimate the importance of such initiatives, but even more important is ensuring that the system that we're spreading awareness of and giving accessibility to works. I can use this opportunity to inform persons of advancements made in the criminal justice system in recent years, and I'll just mention a few. There's been increased use of video link technology, which allows victims and witnesses abroad to give evidence in trials. It is also used for young and vulnerable witnesses so that they don't have to come into the courtroom and have that frightening experience. We've had our judge-alone trials in the High Court, and this gives more transparency in decisions because the reasons must be given, unlike with a jury trial. And these are usually published so that the parties and even the public can scrutinize and analyze them. Speaking of transparency, the sentencing guidelines, which judges are mandated to follow, are available on the court's website. And before new guidelines are issued, there's a public consultation phase that allows the public to give their opinions, and it could help to guide the committee. There's also been use of legislation, which we have for witness anonymity. This was seen in St. Vincent, and that exists, of course, for the protection of witnesses. Now, there are many positives, but still, there are many deficiencies, gaps to be bridged within the system itself. In some instances, gaping holes, which lead some members of the public to sometimes opine that there's no justice in the justice system. Yes, this sometimes stems from them being misinformed or their misunderstanding. But before we become defensive, we may wish to take a closer look at what is sometimes the harsh truth. Ask ourselves, if something were to happen to us, either being accused or a victim, is this the system that we would want to rely on? I would highlight a few gaps that can be found in most, if not all, of our jurisdictions. And this is just the tip of the iceberg. A monumental challenge, the lack of financial resources in all facets of the system. We cannot do the work without the requisite tools. And this is from human resources to something as simple as furniture. It was disappointing to learn that the DPP's office in St. Vincent had to pause their community engagement. This is in terms of reaching their rural communities because of the unavailability of a vehicle. Next, a system cannot be efficient with a faulty or unstable foundation. At the foundation of our systems are the investigations, which are primarily conducted by the police and other law enforcement agencies. Imagine crime evolving to include the use of artificial intelligence, but our police, including our computer experts, have outdated computers or none at all. Another gap. Speaking of foundation, our base courts, where the matters commence and which handle a substantial amount of criminal matters. They suffer from the same deficiencies previously mentioned, but there's also jurisdictions that are still conducting long-form preliminary inquiries, something that can be fixed with a simple piece of legislation. And on the note of legislation, our laws need updating, not just the ones where the failure to do so will result in us being on a gray or blacklist. Justice should be timely, so that we need more robust and effective case management and cooperation from counsel. The criminal procedure rules are almost here, but it's the implementation that will determine the success of them. We know that the matters continue to increase, and so we need more judges and staff, but that would mean more physical infrastructure. Our courthouses have been neglected and barely have the capacity to accommodate the present occupants. That needs to be addressed. Now let's take a step into the community, the persons who come to the courts. Accused persons need representation in serious matters apart from murders. The numbers at the criminal defense bar are dwindling. Same handful of lawyers that service the summary and high courts also have their civil practices. So it may require the extension of the legal aid services because there should be access to fair representation for all persons, despite their limited means. We should also remember that a defendant's rights do not end in the court, because if convicted and imprisoned, basic human rights still exist. And rehabilitation is so fundamental, but it cannot be expected to take place in overcrowded, archaic structures lacking basic necessities, with only promises of a new or improved facility. I spoke about defendants, and they are central to the process, and their constitutional protections should be upheld. But sometimes we seemingly forget the other side, who have already had their rights breached, whether it's loss of life, limb, property, or dignity. From the report to even their attendance in court, they're sometimes treated with disrespect, disregard, or just plain disdain. So this may require a victim's charter or a code of practice, something to prevent further traumatization by the process. This year, I trust that we will execute our respective roles in community engagement, and more importantly, in bridging the gaps in the system. I was happy to hear the Honorable Chief Justice speak of the upcoming projects for the criminal courts. And I hope that these will be bridges that will stand the test of time and restore the public's confidence so that after the community engagement, persons will be met by a system that works, an efficient and an effective one. Thank you.
Thank you, Madam DPP Acting. Mrs. Spencer Joseph comes to us from the Spice Isle of Grenada and the islands of Carriacou and Petite Martinique. She has over 20 years of experience, starting in private practice in 2003 and continuing after relocating to Grenada in 2007. She joined the Attorney General's Chambers in July of 2013 as Senior Crown Counsel, then was the first attorney attached to the Financial Intelligence Unit in 2020, and earned a Master's of Law degree in International Business Law in 2021. On the 2nd of September 2022, Mrs. Spencer Joseph assumed duties as Solicitor General.
It please His Lordship, Chief Justice, and my lords, I crave your indulgence to adopt the protocol list that has already been established, except to recognize His Lordship, the Honorable Chief Justice, Acting Mario Michel, Honorable Justices of Appeal, Honorable High Court Judges and Masters of the Eastern Caribbean Supreme Court, Honorable Attorneys General and my fellow colleagues, Solicitors General across the Eastern Caribbean, Chief Registrars and Registrars of the constituent magistracies, Chief Magistrates and all magistrates. Ladies and gentlemen, good morning to all. My Lord, I'm honored this morning to make this inaugural address to the court on behalf of my fellow Solicitors General of the jurisdictions that are members of this honorable court. I extend to you on behalf of my colleagues, well wishes to you and your loved ones for this new year, and that it is filled with peace, good health, and continued success in your future endeavors. As the court sits on this stellar occasion, under the theme Accessibility and Awareness, the ECSC Bridging the Gap through Community Engagement, it is indeed indicative of the strides made of His Lordship, the Chief Justice, with the Justice in Schools ECSC Public Education Campaign, which involves visits, panel discussions, and activities that promote justice in schools. There was also the Mediation Public Awareness Campaign. We heard of the launch of the litigation portals, and of course, the Public Education Lecture Series with the 2024 iteration under the theme Justice Without Borders. These ventures demonstrate the ECSC's continued commitment to increasing public awareness and understanding of the judicial system and realities of legal practice in the region. But, my lords, it has not stopped there. In Antigua and Barbuda, for example, during the long vacation in 2024, the Court Mediation Committee provided mediation training to young people and their counselors from selected schools from across that territory. And upon conclusion, the students received certificates of participation. It is important to note that the precursor to that training was a poster competition involving both primary and secondary school students so that they can illustrate their perception of mediation. My Lord, the immediate benefit of this initiative is that it exposes young minds to an alternative method of resolving disputes, because it promotes and fosters a more balanced and fair approach to settling disagreements. In addition to which, mediation facilitates communication and ensures that both sides are heard, promoting fairness, a key pillar in the administration of justice, which is a lesson being taught and learned at an early stage. My lords, in most of the OECS member states, the roster of events for the respective Law Week activities would more often than not include community outreach programs, inclusive of prison visits, moot competitions, and pro bono days. My Lord, at this year's Law Week in Antigua and Barbuda, a unique service that will be offered is a free mediation clinic. This will be added to the Legal Aid Day to assist persons with cases before the Magistrates Court. My Lord, I will submit that this mediation clinic, I'll even bet on it too, that this mediation clinic will reduce a backlog of cases and therefore allow the justice system to focus more on complex matters. But permit me a bit to boast, to highlight Grenada's Sir Archibald Ned Memorial Lecture, which is the longest running public legal education series in all the Commonwealth countries. This series is a brainchild of our King's Counsel, Ruggles Ferguson, who is here with us this morning. And this idea inspired other similar public lecture series across the region. These lectures have contributed to a more informed, engaged, and I will even say, law-abiding community. The knowledge gained helps individuals make informed decisions in their personal and professional lives and promotes a better understanding of the law. It is important to have public outreach programs to enable members of the public to understand how the courts operate, and generally for persons to know their rights and duties and how they can be enforced, either through the courts or through alternative dispute resolution procedures. My lords, as we look to the future in Grenada, and I know as well in St. Lucia, as likewise in other jurisdictions, work continues assiduously on the construction of the halls of justice to ensure continued access to justice. It is incumbent on us to ensure that accessibility is maintained in the traditional physical sphere. In addition to advances through the litigation portals, and to ensure that the modernization of court operations remain accessible to the public. My lords, permit me to end with this quote from Mahatma Gandhi, who once said, "An ounce of practice is worth more than tons of preaching." My lords, without acting, we are not going anywhere. Very little will be accomplished. The ECSE has led by example and demonstrated its commitment with progressive steps to make justice accessible to all, and has done so with great success, because the public should not only be able to see the justice system in action, but have access to justice within a comprehensive and transparent framework. The ripple effect is that each member state of the OECS has taken up the mantle with great impetus to afford people the ability to obtain legal assistance, participate in the legal system or get assistance and the necessary non-legal support that they may need, all of which are essential to the rule of law. May it so please the court. I thank you.
Thank you, Mrs. Siobhan Spencer-Joseph. Mr. John Carrington, King's Counsel, comes to us from the territory of the Virgin Islands. The majority of Mr. Carrington's law practice has been in and from the BVI, after stints at the public bar in Trinidad. His career highlights include assisting in drafting early regional anti-money laundering regulations and the first CFATF agreement, acting appointments in the High Court and on the Court of Appeal, and being elevated to the inner bar. His favorite professional memory is receiving his first roll brief in July 1996. To address us on behalf of the inner bar and as representative for the territory of the Virgin Islands, Mr. John Carrington, King's Counsel.
Thank you, Master of Ceremonies. Your Lordship, Honorable Chief Justice, their Lordships, Honorable Justices of Appeal, and Justices and Masters of the High Court, their Worships, the Honorable Magistrates of the Eastern Caribbean region, my colleagues of the inner and outer bar of the region, ladies and gentlemen, good morning. I acknowledge the presence of the heads of state and heads of government of the various territories, especially our own Premier Dr. Beakley, and of the Attorneys General and DPPs of the member states and territories of the jurisdiction, as well as heads of regional judiciaries who have taken the time to join us in the opening of our law year. I respectfully otherwise adopt the protocol that has been established. My lords, I bring greetings for 2025 from the Virgin Islands and the extreme north of what His Lordship, the Chief Justice, referred to as our common juridical space. It is a privilege to be able to represent both the BVI and the inner bar on this occasion. My lords, our courts are busy. Thousands of cases are filed per year, as Chief Justice has reminded us. Several hundred, and we understand thousands now, are heard and ruled on. The judges work hard, and so does the bar. The bar is called upon to work as hard as the judges do, because without the bar, there can be no proper system of justice. The bar is indeed, in my humble opinion, the bedrock of the justice system. Without the bar, causes of action will not be brought before the courts for determination, nor can the courts function without the bar's involvement in distillation of facts and legal issues, and the development and presentation of legal argument for consideration by the judges. When, as frequently happens, the court at the end of a judgment acknowledges the assistance of counsel, these are not meant to be empty words. They are an acknowledgement of the role of the bar in the delivery of justice in a particular manner. So the delivery of justice, my lords, involves the interplay of the courts and the bar. But there is a third element, which is the society in which the courts and bar exist and operate. Justice is not meant to operate in a vacuum. Its purpose is to serve the society, and the court system is an integral part of that society. The development of the notion of justice and the mechanism of the court system to further this notion is likely to be among the most significant achievements of human beings. The longevity of systems of adjudication, whether through a formal court system or merely through individuals such as a chieftain, a king, or chancellor, is testament to that. The mechanisms for adjudication exist in all civilizations, both ancient and modern. While the method of administration of justice may vary widely, I believe that the administration has always had the objective of satisfying the contemporary concept of justice at the relevant time. So if we look at the 21st century, all courts have the task of administering just the current concepts of justice. And to my mind, the two overarching components are fairness and openness. As lawyers, we generally associate the term fairness with the principles of natural justice. And in Lockhart and the Disciplinary Committee, Chief Justice Pereira quoted the judgment of Lord Denning in the Privy Council, in the decision of Canada and the Federation of Malaysia, saying, the rule against bias is one thing, the right to be heard is another. Those two rules are the essential characteristics of what is often called natural justice. They are the twin pillars supporting it. The Romans put them in two maxims, nemo iudex in causa sua and audio alteram partem. They have been recently put in two words, impartiality and fairness. The open justice concept has always existed, even if it probably has only been articulated more recently, beginning with Lord Halsbury in Scott in 1930, that every court of justice is open to every subject of the king. We know from history books, for example, that executions after conviction were held in public. These were but examples of open justice in practice. Justice Japp in the BVI High Court in PG Ventures and Vitadel in 2016 quoted from Lord Justice Burnett in Ex parte Ewing, saying, an important aspect of the principle of open justice is that justice must be administered in public. The general rule is that the public and representatives of the media have the right to attend court hearings. Open justice helps to keep all those involved in the process up to mark. It ensures public scrutiny of what is being done in the courts and assists in maintaining public confidence in the administration of justice. It also reduces the risk of inaccurate and ill-informed comment on court proceedings. Now, we are all aware that these basic premises of our modern system of justice may not have always existed, but the beauty of the concept of justice has always been that it does not remain static. It has always adapted to the changes to the society of which it forms part. These overarching concepts are the embodiment of the adage, justice must not only be done, but must be seen to be done. Fairness ensures that justice is done. Openness ensures that justice is seen to be done. So, why have I said all of this? To my mind, when one speaks on our theme of today of accessibility to justice, it should primarily, in my view, be to the delivery of justice. Not so much that there should be literally or even figuratively a court next door, or legal fees should be inexpensive, but that the public should be satisfied that once a justice system has been engaged, the end result will be a just decision. Equally, when one speaks of public awareness, this should be measured by the openness of the system of justice. How far can we say that in our system, justice is being seen to be done? That there is the ability of the public to scrutinize and criticize objectively, but not scandalously, the workings of the bench and the bar. The court system is meant to serve society, but it must, in my view, sell itself by the quality of justice that it delivers. Our court is now almost 60 years old, and has the enviable reputation of continuously delivering timely justice to our region. I believe that in so doing, it has satisfied its responsibility towards community engagement. That is, that its community is properly serviced. Its adaptability, as we see from the address of the Honorable Chief Justice, and focus on self-improvement in the delivery of justice should be sufficient to ensure that community needs continue to be met and satisfied consistently in the future. It is my thesis, therefore, that our regional community is already in good hands and the gap has effectively been bridged. Thank you very much for this opportunity to share my thoughts, and I wish our court and members of the regional bar a very successful 2025.
Thank you, Mr. John Carrington, King's Counsel. Our next speaker, Ms. Jean Dyer, is a graduate of the University of the West Indies, Cave Hill campus, and U Wooding Law School in Trinidad and Tobago. In 2006, Ms. Dyer relocated from Montserrat to Anguilla and joined the former leading law firm Keithley Lake and Associates. In January 2018, Ms. Dyer established her own practice, J.M. Dyer and Company. Ms. Dyer has a keen interest, in continuing legal education and has served as the coordinator of the OECS Bar Association Annual Regional Law Conference from 2013 to date. She has also served as the treasurer of the OECS Bar Association from 2012 to October 2020, and as the president of the Anguilla Bar Association from 2014 to 2018. On October 3rd, 2020, Ms. Dyer was elected president of the OECS Bar Association. She is only the second female president of the association since its formation in 1989. To address us on behalf of the OECS Bar Association, Ms. Jean Dyer.
Milady, may I with your leave recognize the presence of our esteemed and distinguished guests in the protocol so ably established by the Honorable Acting Chief Justice. Good afternoon, all. I have the honor and privilege of addressing this esteemed gathering, and it is with pleasure that I do so on behalf of the OECS Bar Association in my capacity as president. Milady, for the last 4 years, I have at the end of my speech pledged the OECS Bar Association's commitment to the rule of law and access to justice, and that we will continue to work tirelessly in our efforts to support the judiciary and improve access to justice. This year's theme, however, calls for an examination of how justice is really doing under our watch, and as such, I start with the question, how are we doing? We would all agree that inaccessible courts are a barrier to justice. Our acting Chief Justice has already updated us on the notable technological and other improvements which have been made to our justice system over the last year with a view to enhancing access to justice. I wish to commend our acting Chief Justice and also our former Chief Justice, the Right Honorable Dame Janice Pereira, who demitted office last year, and their team for their foresight, hard work, and dedication, which is most evident from the detailed report and account, which was given to our people earlier today on the work carried out in 2024. Of course, ensuring that the administration of justice is fit for purpose is not exclusively the domain of our courts and the legal profession. Our governments also have a role to play. Whilst we've invested heavily in our e-courts over the last few years, we must ensure that the physical accessibility of our courts is not neglected. Being able to enter our courthouses without barriers is essential to access to justice. It is a right, however, that can too easily be taken for granted. In fact, in some of our member states and territories, there is perhaps a disconnect between our government's rhetoric as to their commitment to access to justice and the lived reality of some of our court users. Some of our courthouses are poorly maintained and or are in dire need of refurbishment and modernization, so that, for example, they are fully accessible by wheelchair users, or they offer vulnerable witnesses separate waiting areas away from the public. These are just a few examples of how we should be modernizing our courthouses. The principle of equal access to justice for all should be sufficient to justify our governments investing in accessibility adaptations and essential court maintenance. Justice is for us all, and not only for those who can pay. This principle has existed from biblical times, as Leviticus 19:15 tells us, and I quote, "Ye shall do no unrighteousness in judgment. Thou shalt not respect the person of the poor, nor honor the person of the mighty, but in righteousness shalt thou judge thy neighbor." For those of us who attended the church service here in Anguilla this morning, that was the focus, and we were reminded of our obligation as lawyers as it relates to the community. The reality, however, is without a system of legal aid that is accessible and effective, the most vulnerable in our societies will not have access to high-end legal support that good justice depends on. If they are left to navigate the justice system on their own, then fairness is lost, and the system has failed them. Unfortunately, this is the reality of several of our vulnerable people, unless they're charged with capital or serious offenses. The legal aid systems in most of our member states and territories are in dire need of reform. Whilst we are aware that there are limits to the public purse, we nonetheless call on our governments to bridge this gap by prioritizing legal aid reform. As the DPP, Mrs. Shannon Jones-Gitton, said earlier, we must all play our respective roles in bridging this gap. In the meantime, the OECS Bar Association's working group, led by our first Vice President, Ms. Yvette Wallace, which we established last year, will continue to explore possible reforms and alternatives to government-funded legal aid. I must place on record our appreciation for all the time and efforts of the members of this working group who are seeking to improve access to justice in the OECS. Milady, last year, the OECS Bar Association, in celebrating its 35th anniversary, launched the Honorable Justice Ian Donaldson Mitchell Casey Award for Pro Bono Law. As some of you may be aware, the late retired Justice Mitchell touched the lives of many vulnerable persons in Anguilla by establishing a legal aid clinic at the Department of Social Development. We considered it to be most appropriate for this award, which will recognize contributions and achievements by members of the OECS Bar Association in the practice, promotion, or enhancement of, or leadership in pro bono legal services to be in his honor. The legal profession cannot be expected to keep the wheels of justice turning over for the most vulnerable and disadvantaged. The demand for help is increasing. And it is for this reason I yet again urge our heads of governments to prioritize the reform of the legal aid system, since in the words of the late Lord Bingham, and I quote, "Denial of legal protection to the poor litigant who cannot afford to pay is an enemy of the rule of law." Milady, these are but a few of the activities which the OECS Bar Association undertook within the last year. Time does not permit me to address the others, save to mention that our regional law conference returned to the region and was held in St. Lucia last year, despite the challenges of regional travel. It was our largest conference to date, in that we had 160 judges and lawyers in attendance. This year's conference will be held in Grenada from the 23rd to the 26th of October 2025. We will provide the judiciary and our members with further details in due course. In closing, as far as the administration of justice is concerned, I renew my personal pledge and that of the OECS Bar Association to be untiring in our efforts to continue to defend the independence of the judiciary and the rule of law. I extend to all members of the judiciary and the legal profession the OECS Bar Association's warm wishes and prayers for good health, continued wisdom, strength, and fortitude for the year ahead. May so please support.
Thank you, Ms. Dyer. Our next speaker, Ms. Moline Barrett, is an attorney at law and partner in the firm Sages LP, a full-service law firm based in the Valley, Anguilla. Her practice areas include banking and finance law, real estate acquisition and development, probate and administration of estates. Ms. Barrett has significant experience in international finance and real estate acquisition and development, and has been consistently ranked in Band 1 by Chambers and Partners since 2016. She's also a trained mediator. Outside the practice of law, Ms. Barrett contributes a significant amount of her time to her church, where she serves as a lay preacher. She's also an avid fitness enthusiast. To address us on behalf of the constituent bar associations of the OECS and the representative for Anguilla, Ms. Moline Barrett.
May it so please the court, protocol having already been established by our Honorable Acting Chief Justice, I bid the court and our esteemed guests good afternoon. It is my honor and pleasure to address you today on behalf of the Anguilla Bar Association and the bar associations in each of the member states and territories. Renowned author and civil rights activist James Baldwin said, "If one really wishes to know how justice is administered in a country, one does not question the policemen, the lawyers, the judges, or the protected members of the middle class. One goes to the unprotected, those precisely who need the law's protection most, and listen to their testimony." If we were to survey the unprotected in our respective societies and ask what are their views on the court and how it operates, what do you think their testimony would be? Will they say that their encounter with the courts have left them feeling valued, welcomed, respected, included, represented, or heard? Would they say that they see the court as somewhere they can go to obtain redress for the wrongs done to them? Or will they say it is the opposite? A lot has changed in our societies in the past 20 years, and so has the society's views of the court. Gone are the days when respect for law and order was a given, and disagreements did not end in lawsuits. Today, people are less inclined to turn the other cheek or to let things slide, especially if they believe their rights are being infringed. You would think that this would translate into greater confidence in the court, given its role, but this is not the case. The fact is, many are less inclined to seek the assistance from the court because to them, the court only works for those who have power or money. Sadly, at the heart of this sentiment is a lot of misinformation, not only about the court and its processes, but about the role that the court plays in society. And this is not surprising, given that historically, the court stood aloof from those it served, observing but never engaging. We, the bar associations, are therefore heartened by the new approach taken by the court. And the theme for this year of opening of the law year, accessibility and awareness, bridging the gap through community engagement, telegraphs to the unprotected in our societies that the court has heard their testimony. However, if we are to continue bridging the gap, greater effort is needed to make sure that all people are equal before the law. But for there to be equality before the law, there must be equal access to the law. Equal access requires people to know their rights and their entitlements, to be aware of the processes for remedy or redress when their rights and entitlements are infringed, and to be able to access those processes and to effectively participate in them. Therefore, access to justice must not only be an aspiration of the court, it must be the inspiration for the bar associations. This is the only way to ensure that the justice system is more than just hollow promises of protection for the vulnerable and the powerless. Therefore, as we chart the way ahead this new law year, we need to ask three important questions. First, can disputes be resolved more quickly and, in some cases, without the need for legal action? One area that comes to mind is mediation, and we were heartened and encouraged by the proposed introduction of criminal mediation. However, mediation in civil matter is still a voluntary process. Further, even though it contemplates that mediation could take place before the claim is filed, very few persons use it. What if the court were to make attendance at a mediation session a mandatory step in the process? And better still, why not require this step to be taken before the court is engaged? That is, as part of the pre-action protocol. Making mediation mandatory at an earlier stage will mean that parties can potentially resolve their disputes earlier and cheaper. It can also free up capacity in the system and reduce waiting time for those cases that need to be heard by a judge or where a mediated settlement is not possible or just. But for this to work, my lady, we need more trained mediators with expertise across different fields. Perhaps the solution is to have all the court-appointed mediators in the ECSC included on one roster. This will give litigants and potential litigants the ability to choose a mediator, regardless of where in the Eastern Caribbean that mediator is. Secondly, how do we ensure that access is affordable when the routes of settlement have been exhausted? This brings us to the vexed question of legal aid. Ms. Dyer has addressed us on this issue, and I won't say much more. However, as bar associations, we believe that there must be a system in place that allows those who cannot afford legal aid services to access the court. This is of vital importance because awareness without access only serves to reinforce the gap. What we have in our jurisdiction, as Ms. Dyer would have explained, is a system that caters mainly for persons charged with criminal or capital offense. However, the vast majority of the unprotected in our societies are not charged with criminal or capital offenses, or do not need criminal law advice. Legal aid should therefore not be restricted only to those cases and only to those who engage the criminal courts. Therefore, to bridge the gap, we must have a formal system of legal aid funded by our governments, administered by lawyers, and extends beyond criminal law advice. Finally, do we have the right infrastructure in place to support this access? The court has made tremendous strides in ensuring that judges can host hearings and hold courts in the digital age, and this gives confidence both to court users and lawyers. However, what about our physical spaces? Are they suitable for purpose? Have the halls of justice projects fallen off the agenda in some of our jurisdictions? That is a question that we need to answer, because the courts cannot continue to operate in unsuitable environments. ensuring our physical infrastructure is adequate and suitable for purpose is one of the most powerful messages that we can send about the esteem with which we hold the justice system, the esteem and value which we attach to the rule of law, and the conditions that we think are right for litigants, judiciary, and court users to be in. As we close, my lady, lest we forget, access to justice is not a privilege. It is a fundamental right that underpins the rule of law. As such, every actor in the justice system has a role to play. The court is playing its part because it's taking steps to improve access. The governments have to play their part in funding legal aid and the physical infrastructure. And we, the Bar Association and the lawyers, must play our part as well. In fact, I dare say we need to do more. It is not enough to give back only during Law Week. We are called to a noble profession, and a part of this nobility is the fact that we give back. Giving back should therefore be a staple in our practice rather than something we do once a year. I close with this reminder from Aristotle. At his best, man is the noblest of all animals. Separated from law and justice, he is the worst. May it so please.
Our next speaker comes to us from the Emerald Isle of Montserrat. Mr. Horace Sullivan holds an LLB and a master's degree in human rights with politics from Birmingham City University. He began his legal career upon being called to the bar in England and Wales as a member of the Honourable Society of Lincoln's Inn. After returning to Montserrat in 2004, he was admitted to the Montserrat Bar as a barrister and solicitor, practicing in all courts. In 2013, he was appointed Director of Public Prosecutions. Mr. Sullivan has appeared in all courts in Montserrat and at London's Privy Council. He is dedicated to mentoring young professionals in the legal field to promote excellence in the profession. To address us on behalf of the senior members of the Utter Bar and as a representative for Montserrat, Mr. Horace Sullivan.
Madam Chair, I thank you for the opportunity to address this court. I would like to, with your leave, to adopt the protocol which has already been established. Madam Chair, I run the risk of being accused of plagiarism, since what I propose to say has been said by many of our speakers previously. As I reflect on the court's theme for this year, and indeed my own presentation, it suggests a number of things to me. It reflects access to justice, both in physical space and in cyberspace, and an outreach program which reflects the court's changing attitude to the way law is dispensed. As I did on the last occasion, when I spoke at the opening of the law year, I start with the prophetic quotation of former Justice of Appeal, the late Don Mitchell. He said, "If our judiciary is to maintain the respect of our societies, the traditional qualities of impartiality, independence, and integrity will need to be maintained and strengthened, and new practices will have to be adopted. The modern West Indian judge," he said, "will increasingly be called upon to adopt old principles to modern realities." Justice Mitchell continued, "Judicial impartiality will increasingly be challenged by the modern ethic of corporate marketplace efficiency. Judges will be called upon to practice management reforms, show more effective use of resources, be more responsive to the needs of society, and more accountable for their actions. We will be asked about our performance results and subject to performance-based budgeting systems, all imposing a greater risk of political direction. In the ever-evolving landscape of the legal system, the integration of technology into our courtrooms has become more than just a trend. It is a necessity. As society undergoes digital transformation, the legal sector must keep pace to ensure efficiency, accessibility, and transparency. This is particularly true for the court system, where technology and impending artificial intelligence explosion promise to revolutionize the way justice is administered. The response of the justice system to the coronavirus pandemic has demonstrated something that has been so critical to its success through the ages: its ability to change and adapt in order to meet the changing needs of our society. The increased digitization of our justice system was already a priority prior to the coronavirus pandemic, because we knew that in our modern world, many users want the option of access to the courts as they access other types of services. Continuing to modernize the system will be crucial to the safeguarding of its ongoing success. I think it is important that we look at the period ahead. We can use it as an opportunity to improve the systems for everyone who uses our courts and tribunals to create a better system. This will make it possible to open up justice to more people and make our society fairer than it has ever been. That is what I believe is possible. There is no doubt that the time ahead of us looks very different than it did just a few short months ago. But I hope and trust we can all work together to realize a smarter justice system for what will be a very different future. Perhaps more significantly, the court makes a great effort to reach out to the public to explain its work. We live in an age in which people do not accept public authority without question, and the court, like other public institutions, has learned to explain itself to those members of the public who wish to inquire about its work. The drive to enhance accessibility and streamline processes stand as the foundational reason for the courts to wholeheartedly embrace technology. The integration of digital platforms introduces transformative capabilities, facilitating online filing, case tracking, and document management. This not only reduces the burden on physical infrastructure, but also minimizes bureaucratic red tape, contributing to a more agile and responsive judicial system. A noteworthy example of technology's impact on accessibility is the implementation of our online filing systems. Traditionally, the process of submitting legal documents involved intricate paperwork and manual submissions, often leading to delays and inefficiencies. With the advent of digital platforms, legal professionals and litigants can seamlessly file documents online, reducing the reliance on physical paperwork. This not only expedites the filing process, but also ensures the timely submission of crucial legal documents. Moving beyond filing, the introduction of digital case management systems exemplifies a pivotal step in modernization of court processes. These tools empower judges, lawyers, and stakeholders to access case information, schedules, and documents remotely. For example, let's say a legal professional need to review case records, track schedules, or access relevant documents outside of the courtroom. A digital management system enables seamless remote access, reducing dependency on physical case files and facilitating efficient case preparation. Moreover, the digitization of case records significantly mitigates the risk of document loss, a common challenge in paper-based systems. With digital archives, the likelihood of misplacement or damage of crucial legal documents is minimized, ensuring the integrity of case records. This not only benefits court personnel by streamlining administrative tasks, but enhances the overall speed and accuracy of legal proceedings. In essence, the embrace of technology, particularly through online filing systems and digital case management systems, not only address accessibility challenges, but brings forth a paradigm shift in the efficiency and effectiveness of court processing. The resulting synergy between technological innovation and legal administration lays the groundwork for a more accessible, transparent, and trustworthy judicial system. As much as the court has done, there is still much to be done. Early in my career, there was a move afoot to build the halls of justices throughout the OECS, with the court taking the lead and the governments of the region paying their fair share of the building costs. It seems to me that that project has stalled. It is my fervent wish to see the project get off the ground. In my own territory, there is an urgent need for a purpose-built facility to serve the needs of the people. The current structure has outlived its usefulness. If we are truly serious about access to justice, then this should be the clearest starting point. Defendants and litigants should have no difficulty in entering a courtroom to access justice. The old and the infirmed should have the same opportunity to access the court building as the able-bodied. When this is done, we can truly say there's equal access to justice. In closing, we can see progress with regard to outreach, but more needs to be done. Not long ago, I saw current Chief Justice active in the community colleges in the OECS. I think this should be extended to the law schools and the primary schools. I commend the CJ's vision and invite him to take the level of outreach further. The court users of tomorrow are the youths of today. It is important to reach them now. With that, I suggest further outreach, and I've already said, to the secondary schools and the primary schools, as well as youth groups in our community. Social media is the medium of choice for teens and young adults. We must use that as well. Create remote programs that reach out to students who are still at school, which involves remote meetings, allowing them to interact with judges, gauging their understanding of how the courts work. And finally, I urge the court, as well as our governments and people, to embrace the idea of legal aid. May it please you, my lords.
Thank you, Mr. Sullivan. As we move from the Emerald Isle across to St. Kitts and Nevis and welcome Ms. Mizelle Casilda O'Brien, a practicing attorney with 21 years experience. She practices extensively in various areas of law. She is a very experienced civil litigator. She has been a partner in Dublin and O'Brien, and the Dublin and O'Brien firm from since November 2016. Ms. O'Brien is a notary public and an accredited director. She's a past secretary of the St. Kitts Nevis Bar Association. Currently, she serves as a director on the Social Security Board for the Federation. To address us on behalf of the senior members of the Ottawa Bar and as the representative for the St. Kitts and as representative for St. Kitts and Nevis, Ms. Mizelle Casilda O'Brien.
Thank you, my lady. My Lord Chief Justice, in the interest of time, kindly allow me to adopt the protocol previously established. I extend warm greetings and best wishes from the Twin Island Federation of St. Kitts and Nevis. Ladies and gentlemen, good afternoon. I am grateful for the opportunity and happy to speak as a senior member of the Ottawa Bar in the Federation of St. Kitts and Nevis at this auspicious event. As we embark on this new law year, I trust that as practitioners, we will continue to endeavor to provide quality legal representation and access to justice in a timely and professional manner. Our court is not just a physical space, but it is a public service. As such, and bearing in mind that our world is dynamic, we must be mindful of our duty to close the gaps that currently exist and be ready to address any other gaps that will inevitably come to light over time. Regardless of our desires, time pushes forward, and as global citizens, we should want our societies to develop and improve. I join my colleagues in applauding our court in improving access to justice by the creation and implementation of the e-litigation portal and the ECSC Public Education Campaign. In this jurisdiction, we have the Law Commission website, which gives the public ready access to legislation enacted in our country. That is a step in the right direction. Also, litigants can now attend hearings remotely. This allows access. Nevertheless, there is still much work to be done, and we must maintain the momentum. Humbly and with your leave, my lord, here are a few gaps which I would like to address. Firstly, access to credible information. We live in an age where the atmosphere is saturated with information. However, when engaging in conversations with persons outside our profession, one wonders if the reliable information is reaching the layman. Many persons are unaware of their rights and the services available to them when these rights are infringed. Still, the goal should not only be making the information available, but ensuring that the information is communicated in a variety of ways so that it can be comprehended at different levels of understanding. It is one thing to communicate, but if the intended audience does not understand, the result will still be chaos. We must ensure that despite one's social or economic standing, all persons have access to justice. I propose that there is a need for continuous public education, and this can be achieved in a number of ways and will require the collaborative effort of the Bar and the Ministry of Justice and Legal Affairs. Public lectures and panel discussions should be more frequent and regular on timely topics of interest. More awareness should be raised on topics such as peaceful dispute resolution, family law issues, property disputes, citizens' rights, and powers of arrest. We can do some more sensitization on the sentencing guidelines, thus removing the mystery and enabling our community to understand how the law works. We have observed how YouTube channels are used by various organizations and persons to disseminate information. We have the software capabilities in our courts to do so, and I propose that we should live stream the delivery of judgments that impact our communities greatly. We should also encourage the public to listen to the live stream of judgments from the Privy Council and the CCJ on their respective websites. Short public service announcement videos on constitutional rights and criminal law can be created and broadcasted on the national television stations, bringing the law which protects our society into the private spaces of our community. In our jurisdiction, there is also the need for an adequately staffed and functioning law library. Also, free legal aid clinics should be made permanently available in the rural areas. Secondly, lack of resources. There is a lack of physical resources. At one point in the 80s and 90s, there were magistrates' courts sitting in 5 areas in the Federation. Now, the number of cases have increased exponentially, but the places for sittings have decreased to 3. I humbly suggest that the judicial services should be extended to these underserved populations. It will minimize the cost to the litigant who has to travel from the countryside to attend their hearings. Most hearings are intended to be conducted in open court. It is important that the general public be able to attend and observe these open court proceedings. Our current facilities, however, in St. Kitts particularly, hardly provide enough space for the lawyers in attendance and definitely not enough space for the general public. This gap needs to be addressed urgently. Interested persons should be able to attend and listen to open court hearings at all levels. The public should not be restricted. There remains an urgent need for more litigants to be able to access the legal aid clinics to initiate more and a wider variety of matters. Also, where counsel other than state employees provide legal aid, there should be prompt payment for such services, bearing in mind that such persons have financial commitments to their staff and other operating costs. As it relates to the lack of human resources, just as counsel should participate in continuing legal education, clerks and administrative staff in law chambers and court offices should undergo periodic training so that the experience of the client litigant can be more service-oriented and we can raise the level of professionalism. It is also suggested that sensitization training be offered to media personnel so that there can be more reporting on court hearings in the mainstream media. The final gap which I would like to highlight is outdated laws and lack of legislation. Some of our laws do not reflect modern times and the needs of the people. Periodically, a consultation and reconciliation process should be conducted to obtain feedback on what may be considered antiquated legislation. We should not let the law and morality debate make us apprehensive in updating our legislation in the areas of sexual and reproductive health for women and drug abuse and mental health. Is the current legal framework addressing the needs of the most vulnerable of our society, such as the elderly and the homeless, is a question we must ask ourselves. We need to look at our local circumstances and the challenges and discern what legislation needs to be updated or passed. In conclusion, my Lord, certainly we will have to continue to assess and make appropriate changes or risk remaining static. May it please this honorable court.
Thank you, Ms. O'Brien. Time constraints do not allow us to hear from our final speaker, who hails from the Gem of the Isles, St. Vincent and the Grenadines. However, I will invite Mr. Jamali John to share his address with us on the website of the Eastern Caribbean Supreme Court. This brings us then to the end of today's proceedings. As we come to a close, I take this opportunity to thank the Honorable Chief Justice Acting, Mr. Mario Michel, for his inspiring feature address and to extend thanks to all of our speakers who addressed the court this morning. Special gratitude is extended to the agencies for public information and the Government Information Service of each member state and territory of the OECS. I also thank you all for joining us, both in person and virtually, to commemorate the opening of the law year 2025. I wish every and each one of you a successful law year 2025. Thank you.
All right. This special sitting now stands adjourned at night.